Hello, my name is Jay Chauhan. I'm a mentor at Angel Mentorship Group, and uh, and I have with me today is in the program Shalaka Gujjar, who is also a member of the Ontario Bar and also a member of the Indian Bar. So we'll talk about the common law jurisdictions and how does the ILA work in the common law jurisdictions in particular. There are some variations in how it works in different countries, even if it is the same common law. My background is that I'm a member of the Ontario Bar, where I've practiced most of my years, and I'm also a member of the Indian Bar in Gujarat, India, and I'm also a member of the English Bar at Lincoln's Inn. So I have Shalaka, if you can introduce yourself also to the audience.
Hello, sir. Thank you. Thank you again for giving me this opportunity. I am Shalaka Gujjar. I am from India, originally from India. Now I am practicing in Canada. I was called to bar in India in 2009, and I'm called to bar in Ontario in 2022. So I'm mainly practicing in family law and civil litigation. And today we're here to discuss about the topic of independent legal advice.
Thank you, Shalaka. So I'll begin by explaining the little bit of the history of the common law from which the issue of the independent legal advice, for short ILA, arises. So in the English jurisdiction, where the common law began in England, the barristers started taking cases one person at a time to the court system where the common law was developed. So what has happened in the common law jurisdiction in England, in this jurisdiction, meaning the legal system, was taken to many of the former colonies of Britain, including Ontario, and to other countries like India. And there are 60 other countries which are now called Commonwealth, and they all have more or less the common law system. And the tradition of the common law arose in England, and this is the way it was developed actually. So each person's issue legally was taken first to the barrister in about 13th century, and in about 18th, 19th century, the profession of the solicitors was developed. So they talked to the client, and they took the case to the barrister, and the barrister would take a particular issue to the court, and the common law, including contract law and tort, were developed. But along with the development of the common law areas of law was also the development of professional ethics, in which the concept of independent legal advice arose. So what happened in terms of the role of the lawyer in the English jurisdiction was that each cause of action was taken by a lawyer, and the law and the fact were interpreted for that particular situation by the lawyer and then argued before the judge. So to protect each person's interest, the idea developed that each cause of action must have a particular lawyer, and a lawyer would then bring it to the court and then first attempt to negotiate the resolution of the problem with the opposing party, and that opposing party is also representing his client's interest. So when there's a conflict, each person in the common law has their own legal advisor. So that's the basic principle that is followed through, and it's a little bit different than the civil law, in which the declaration of what is the law was declared as a state creating and enacting the legal system, which applied to all the citizens. In civil law and the criminal law, and the causes of action, civil law and the criminal law were defined in a code of the civil jurisdiction that were created in the civil law jurisdiction, which is like European countries, and many of the colonies of France also follow the same concept in their legal system. But the common law of England applies to many of the jurisdictions, including India and Canada, except for Quebec here, where the common law is applied. So the summary of the basic point I'm making is that in the common law, it is very fundamental that the right of the person is identified as a cause of action in any particular situation has to be taken up by one lawyer who will represent that legal interest, and that interest must be protected by that lawyer, and there must be another lawyer on the other side. And if the lawyer assesses that there is a conflict, then in the resolution of the conflict, he must advise the parties that each party must have a separate lawyer. So that's the basic concept of the independent legal advice, and for short, ILA. So I think any comments, Shalaka, you have on that issue?
I feel you have explained it very well, sir. Basically, independent legal advice is to be given so that both the sides, there should not be any conflict of interest, and both the sides should be able to appreciate the nature and consequences of the decision to be made. So I think you have explained it in a very very good manner, sir.
So I want to, Shalaka, now explain basically how does it apply in specific situations. So I just want to illustrate a situation of the real property law where the concept of the ILA is applied in the arena of the real property law, which is the situation where a person conveys the property to another person, let's say B, and it can happen when the transaction is at arm's length, or it is also in a family context where the parties want to transfer the property from one to the other within the context of family situation. So if you were in the civil law jurisdiction, such as Quebec or France, what would happen is that the notary would represent both the vendor and the purchaser, and he would record the change of ownership from one to the other person. However, as the law in the common law jurisdiction has evolved around protection of the legal interest of the buyer being different than the vendor, then there are two different lawyers, which is what happens in Ontario. A large number of, and a large proportion of the lawyers, especially young lawyers and new lawyers, do real estate for that reason, because it's an area where it is easy to, and most people need that kind of a legal advice, and therefore they go to the lawyer and they end up acting for the clients in that situation. So when you have a family situation, the rules of professional conduct also make an exception that you do not need to then look at the property title. You do not have to. If the client says that you need to, then you have to provide, of course, an opinion on the title. But very often you may do a transaction between family members as a part of your estate plan. For example, if you want to give a property to a spouse, then of course it can be given if the consent is given for a lawyer to act on both the sides. But it's very prudent for the lawyer to have independent legal advice. And I want to illustrate this point by giving you an example of a situation that I went through in my practice some years ago. And here's what happened. There was a husband and a wife where a spouse was diagnosed with cancer, and the parties anticipated that the person could die, and therefore they wanted to protect the interest of one child who was an adult child and wanted to give the property to that particular person as a joint owner. So I represented the parents, and the parents together came to the office. I documented all the meetings in which they confirmed in writing that they would want to transfer the property to the child who was living, an adult child living with them, and so that if any person died, then there would be a total of 3 persons on the title. Now, one of them was anticipating cancer and dying, and therefore there was a need to make this property transaction so that the transfer did not have to be done through other documentation, but through the transfer of the property as joint owner. So the 2 persons who have a common interest in making this transaction as vendors or transferors are the parents, and the person receiving the property is in fact the daughter or the child. So in this situation, I represented the parents and I recommended to them, based on my evaluation of the need for independent legal advice, that the child obtain their own lawyer for the purpose of the transfer, so that the person can, the other lawyer can advise the person that they are recipient of an interest in the property, which can be very valuable. A typical property in Ontario can cost anything from for $1 million to $2 million. Is a very large, so to speak, gift that is being transferred to the transferee, and therefore very important transaction happens, which essentially is a tool in Ontario for the saving the cost of inheritance or making a change in the property ownership through the will. So in this situation, I acted for the parents and they signed all the documents, and I did the transfer on the computer. Now, in the recent days, in the years, all the transactions are conducted by the lawyers who are registered specially for the purpose of making the change of ownership based on the instructions of the client, and you can do them directly. In my days, when I was starting practice, we used to have to go to registry office for Richmond Hill. It was Newmarket, and you would register the property there and give it to the clerk for the registrar's office, and they would stamp it as of the time when we made the transfer. In this situation, in the subsequent years, there is a program called TerraView in which you can make the transfer between the lawyers if there are two, and if you're doing it yourself, there's a lawyer that's basically making all the transfer on the computer. So in this situation, the transfer was done. I reported on it, and everything was fine. The daughter did not get independent legal advice, and as it happened, that there was no question marks at the time the transaction took place. I reported, I was paid my fees, and then subsequently, after some time, it was discovered that the spouse who was supposed to get cancer never got, and she survived the operation, and she survived. But the family fell apart. The dispute arose between the husband and the wife, and they ended up in the courtroom for a separation. At that time, one of the spouses basically argued that the transaction was not understood in terms of the ownership concept of joint ownership as to the right of the transferee, that anytime in the future, once you make the transfer to the transferee and there are three owners, that all three owners have to agree to make any changes or sell the property. This was not acceptable to the person because they were separating. So naturally, the first person they want to blame is the lawyer. So I think that I had some correspondence from the lawyers asking, how did I advise? And of course, the solicitor-client discussions are confidential, but I think that in terms of there's an allegation of negligence, then you have to open the chapter to explain what actually was understood by the client and what actually happened in the meetings with the lawyer and the client. So I explained that to the other lawyers, and essentially it ended up that they understood the concept of independent advice, and I explained to the lawyers who were in the picture that the transfer was done by one person representing the interest of the parents, and that I'd advised the child, the daughter, to have an independent lawyer. But she did not have a lawyer, but the parents' interest in conveying the property was properly represented by one lawyer, and therefore it was a proper transaction from my point of view. So as it happened, they didn't want to commence an action against me for negligence, but then each person, there were three lawyers there, separating spouses, husband had a lawyer, the wife had a lawyer, and the daughter appointed a lawyer. So this is a separation action in which the parties were looking to figure out how they would divide the property. And I became a witness in this arrangement, and each of the three lawyers examined me in terms of what I had said to the parents in terms of the advice that I'd given to the parents at that time. So you can see from that arrangement that when you are advising the clients, it is not at the time of the advice that something goes wrong, but it is a time something changes in the lives of the people that you advise, and they're looking to see if you can blame the lawyer for then saying we didn't understand the legal advice or joint ownership of the property. So three lawyers all examined, the recording was done as to what I'd said and so on. But I think after going through, all the three lawyers finally came around to understanding that the issue of the ownership of the property would have to be dealt with according to what they had decided at the time, and that I was not negligent. And so I was just a witness in the situation, and I didn't get any action commenced by either of the parties to say that I was wrong in my advice to the parents in telling them as to how the joint ownership worked. So that's how the matter was concluded. I tell the story in detail so that the listeners to the story, and Shalaki and you in particular, would like understand my understanding of the ILA. Because when the law of independent legal advice is taught in the school, especially by admission course, what you learn is the fact that you represent one interest at a time, and you must ask the other party to have independent legal advice. So how does it work is very fundamental in the practice. If you look at the rules of professional conduct, almost 3/4 of all the rules, in fact, pertain to this concept of how the independent legal advice concept works in the common law jurisdictions. So that's particularly my point that I want to make, Shalaka, and I'd like to hear any question that you have from what I described.
I also have one of the incident where recently I was preparing a separation agreement for one of my clients, and there was the parties, both of them have reached to they've reached to a conclusion for deciding all the issues between them. So there was no I mean they didn't wanted to have a separate lawyers, but then because it was a matter of divorce and a separation agreement, I advised my client's spouse to go and get the independent legal advice, and get the certificate from the other lawyer, so that when we are proceeding ahead, we know that his interest and his rights are also being protected in this process. So, yeah.
So I just want to emphasize, Shalaka, so I would agree that it was in your situation when the spouses have a disagreement, such as in a situation is that of a separation, they need independent legal advice. So let's just examine the institution of how people get married and when is it they need the independent advice and when they might not need the independent advice. So I just want to go through, for example, when husband and wife get married, then there is a common interest. But even though the interest is common, it's extremely important that if you're drafting an agreement of marriage contract, so-called in the everyday language, they call it the prenuptial agreement. In the legal terms in Ontario, it's called the cohabitation agreement, which can be done at any time before you get married, during the marriage, it can be done. But I think if you're separating, then you have to prepare a separation agreement. So the conflict of interest in the time of marriage is not a real conflict because both parties agree, but it's still very important that a dispute can arise in the future, which you have to take into account, and therefore you must have independent legal advice. Now, if you're separating as spouses, then you must have independent advice because the interest of each person is adverse in respect of the issues of property, assets, the access to the children, and the arrangement for making the payments of the support obligation of the person who has a bigger income than the other spouse. And that arrangement of the payment has to be done properly based on the Family Law Act, and therefore each must have a separate legal advice. So Sharaka, I would agree with you that in identifying that there is a conflicting interest in the separating spouses, you must have independent legal advice. So I think that not only must you have them, but the documentation of that arrangement is extremely important actually, because even if the separation was done by way of a meeting with the lawyer, that It is not sufficient to simply say that parties agreed, but there must be a sufficient amount of disclosure. So the rules of disclosure in terms of the financial statement and all those details have to be agreed to between the parties in careful detail and documented, because you don't want the agreement to be set aside. And it is more likely that the court would agree to set it aside if the full disclosure was not made. In addition to the ILA, and the way it works for each situation is somewhat different, actually. I think that in the incident that I described, the parties, once married, they can own a property. At that time, if you buy the property together, that the husband and wife in buying a house, for example, can have one lawyer, and the vendor who is selling the property to them may have a different lawyer. So each time, it is not just a person alone that is required. I mean, if you have 5 people working together to create a company that's going to buy the property, then they can all work together and ask one lawyer to be their lawyer. And the other side who is selling the property should have a different lawyer. So that's roughly the idea in the concept of the ILA. So does that resonate with you, Shalaka?
Yes, definitely, sir.
So I think I'm going to move forward by explaining actually that what is the way to assess the degree of conflict. And I say the degree of conflict is because sometimes you see, I want to illustrate it by in the corporate law. The degree of conflict is something not taught in the schools. It's degree of conflict, meaning that when there is a possibility of a conflict of interest, the amount of conflict is not necessarily the same in each situation. For example, if you are a lawyer for a corporation and the shareholders come to you, maybe 2, 3 in a small company or 5 of them, and say that we would like a shareholders agreement. So the parties who come together under the, so to speak, the umbrella of a corporation are not in fact, having a conflict at the time of drafting the agreement of shareholders. They're coming together to make sure that if a dispute arose in the future or certain investment had to be made in the company, then they would have some criteria for deciding how to resolve the dispute as between the various people who were coming together under the umbrella of one company. They would have a role as a director, they may have a role as a shareholder, some of them may be employed by the company. And to define each person's interest, you would be writing out an agreement. See, if it's a shareholders agreement, it would be different than employment contract. And therefore, at the time of preparing the shareholders agreement, you might have one lawyer. If you are that lawyer that the parties have appointed to say, would you prepare for us a shareholders agreement, then what is advisable for the lawyer to do is to act for the company and then write for each person a letter or email or something that indicate to that person, other person, that you may seek independent legal advice to understand the agreement, but I'm only acting for the corporation. And you should have this in writing to make sure that if the conflict happened in the future, that you have advised them and then they decided not to get independent legal advice at that time. And that is very fundamental. If you didn't do that part, the conflict is very possible in such a situation, and then you could be blamed as a lawyer for not having telling them that there was a potential conflict, and therefore you needed independent legal advice. So what the point I'm making is that it is not just the fact of an existing conflict, but a future conflict that you also have to deal with. And higher the degree of risk, greater is the need for independent legal advice. So you'll come across as a lawyer during your career many situations where the degree of conflict is not always the same. Now, this part of the fact that you have a conflict or not a conflict is not a uniform category. So it's very important for the lawyers to understand and assess. So there's a certain amount of risk taking for the lawyer in making the assessment, because most of the time, as we work in most of the jurisdictions in common law, the system of advising is a private enterprise law firm which is in the position of a business, and therefore the clients always come to the lawyer, and that's the biggest challenge, to advise the clients that if you want to save the money, then save the money, but you should not be busy blaming the lawyer. So how can the lawyer make sure that he's not blamed at a subsequent event when the conflict does happen? So when that happens, it is the duty of the lawyer to try to make an assessment in terms of asking the client for the adverse interest to appoint a different lawyer, in terms of having a lawyer that will represent the opposing interest independently. And for that reason, the rules of professional conduct also require that each time that you deal with a party, you would look through your list of the client base and then check that there is no conflict of interest. The conflict of interest means that information gathered from that client before, and if you're representing that client before, and he was a client, that you should decline to be engaged by the lawyer when the conflict of interest has happened and the opposite party comes to you for a different issue, and that the previous knowledge that you had of the situation does not make you in conflict as a lawyer in acting for the client in a new situation. So these kind of issues arise, and there are many variations which we will not be able to examine in this particular meeting, but are relevant for the lawyer to understand. And the details of how you understand it and make your assessment is partly in a situation of experience. But in this meeting, I'm just trying to make you sensitive that it is important to make this evaluation, because a lot of cases in the common law jurisdiction, especially Ontario, where you look for the negligence, then ILA shows up as a category in which you can become negligent. So I have a history in my career that I've never been found negligent in any situation, my 50-year practice. And I'd like to suggest to all the members of a group, including you, Shalaka, that we should practice in such a way that we do not give the opportunity to the client to say that if you want to save the cost, that what should they do to make sure that we are not put in the position of conflict. And some of the conflict will be assessed. You will see in your practice, Shalaka, that we are put in the position of a conflict partly because of some of the cultural norms that you will see in some communities where the relationships are perceived differently. So there's not the common law jurisdiction is more an English jurisdiction in which the perception of the conflict is seen from the culture of that society and then made into a legal principle. But some communities have a different understanding of the conflict, and when you try to explain it to them, they have difficulty accepting the idea because it costs extra money each time you have a different lawyer. And each person may have a different idea as to how to assess the conflict and what do you do to protect the interest of the client in advising the client in the adverse advisory role. So that is why I think in more recent years, I'm noticing that the younger lawyers are preparing themselves by telling the client that where necessary, it is not just a question of independent legal advice, which may cost anything from $300 to $500 to $700 range, but you might need to do something. For example, you prepare a contract, and in drafting a contract, you are telling the other party that you should have another lawyer. So the other lawyer might simply say, either this contract is okay for the other person, or say that I like to change it. Like, for example, a separation agreement. Then all the changes that you make are not just an opinion on the document, but also advice to the client that you need representation to change the agreement, and making the changes will take further amount of time, and therefore the fees will be different. And then you have the new term coined that I hear more often these days, is that you are now not only doing the ILA, but independent legal representation, ILR. So it's very important to understand the difference between the two, and then you act accordingly to make sure that if you need to take any action, that you take the action appropriately to tell the client in writing and record it that you told the client that you need to change something in the documentation or take further steps to protect their interest. So that is something that I've seen, Shalaka, very often in the practice, where I've seen in our own group as well, that a lawyer can be found to be negligent because they did not take further steps necessary, because somebody simply says, yes, this document is right or wrong or different. It is not sufficient, because you're the lawyer and you making the assessment that it can go wrong because the document does not fully express the point of view of the person, and the person will likely not remember it in a few years' time when they come back and say, well, I didn't understand what you said. And therefore, it's very important to understand how the depth of the understanding of the client is, and then you have to take the measures to make sure that you do documentation and changes that are understood by the client in the way you want them to understand. So any questions on that issue?
Not really. That was really nice. So, I mean, the explanation was very good. I mean, it was very crystal clear.
Good, good. I'm glad to hear that. So I think let me explain now. How do you do what I call a certificate of independent legal advice? You see, what I would suggest, let me explain, Shalaka, the practice of how the certificates are created, actually. See, sometimes, and more likely, sometimes you'll say, for a bank, for example, the banks will tell when there is a client who is has a spouse and borrowing the money from the bank will say that, okay, ask your spouse to have independent legal advice. So because the parties are saying that in the relationship of a spouse, you may be looking at a different interest that the spouse may have, and when they sign a guarantee, it is going to bind the two parties, both the parties, because they're guarantors. One party is borrowing the money, the second is a guarantor. So how would you do the certificate of independent legal advice? I've seen this a number of times, that the bank simply asks for ILA certificate, but do not prescribe the definition of what are the wording that they want you to use as the ILA lawyer. So what I do is to tell the person coming to you before they come that you should obtain the wording, if possible, from the lawyer that is acting for the bank, and then that person or the bank manager will be satisfied with the words, so you do not go back and forth. Because I think that by simply saying ILA is not one category. I think that for that reason, very often what I did was simply prepare my own certificate of ILA, and or in particular situations, and then showed it to the client that here's what I'm going to sign. So if you think that your other party will not be happy with that ILA certificate, then let me have the wording that they have in mind, and I'll go through the wording, so that in the meeting that we spend time, we do not go back and forth until somebody is happy. So it's not possible or desirable for a lawyer to try to guess what the other person might want. So I think so for those practicing, the biggest challenge is to try to identify the wording of the ILA. And typical wording will tell in the document that you've been advised independently, and at the bottom of that statement, there's another certificate or statement saying, which is signed by the client, to say that, yes, I received the advice on this particular day, and that I was, basically the lawyer was acting independently of any interest of the other party, and that they have received advice, and accordingly, it is a complete certificate. But that certificate and what is going to be said in it should be satisfactory to your client in the meeting, but also to the opposing party when it reaches them. So what wording that you use are not entirely uniform, because some lawyers basically think it is a standardized agreement. It is not, in my view. So therefore, you should obtain the wording from the other lawyer if necessary, or use your own wording and make sure that it's going to be acceptable. So I think there's something, Shalaka, that I want to just point out that it may be very helpful to understand in terms of the practice. And this is the part that you will not be seeing in the bioadmission course or in the teaching system in Ontario. But I think that in Ontario, very unlike India, Indian jurisdiction, it is very common. In fact, the average record of finding a lawyer basically negligent is very common actually, because what happens here is that if the parties have very high expectation of the lawyer to begin with, and in the high expectation of the lawyer, you're looking to see that if something went wrong, is when the party goes wrong. For example, you sign a certificate of ILA for a guarantee arrangement with the bank. The problem does not arise at the moment when you write the certificate. It's when that person is sued. And that time, the person at the time of signing is very quick to sign because the husband needs, for example, some money from the bank. And at that time, the getting the money is very important. But at the time the husband couldn't pay and the wife has to sell the house to pay the guarantee, for the guarantee, then it becomes relevant to figure out that how did the house suddenly get into litigation to pay the debt of the husband. And then she goes to another lawyer, and then the lawyer says, oh, well, possibly you didn't understand it. The lawyer made a mistake, and therefore you sue the lawyer. So that kind of litigation is fairly common in this jurisdiction. It is not very common in India, for example, where it is different in the sense that the whole concept ILA is not seen the same light because of a different culture. And therefore, when you advise in Ontario, a client, you have to advise, this is not taught, by the way, currently in the materials that you will see in the bioadmission course, that you have to assess not only the fact of ILA, but the understanding of the culture of the person that you're advising, and then deciding how much in depth would you like to go to explain the concept, how much you will document it in a permanent record you should have, because the problem, if it comes back to you as a lawyer, will not happen immediately. It can happen after a fairly long time, and the Limitation Act may not apply until the client becomes aware under the Limitations Act that the client wants to make a claim for negligence against the lawyer because they suddenly thought it was so easy to make a signature and we keep the bank happy. But when that person was sued, then the lawyer suddenly becomes negligent in their eyes. So I think that it is something very important, in my view, to deal with in the practice. So any questions on that issue?
Not really, sir.
So I think I've covered a fair amount of ground in terms of the principle of ILA, and just the last portion for the clients. Actually, would that be clients that we have in our practice? The first question that will arise very often, because we're in a private practice, and the clients normally, in Ontario jurisdiction, the clients are very much more, I would say, aware, if you like, in the legal terms, because of the Google searching, awareness in the school system, that they are much more aware. So they're always asking, how much would it cost? So there's shopping around that happens. If you get trapped into the shopping around arrangement, and then the client then comes to you and says, okay, how much is the cost of ILA? Another lawyer will quote them, let's say $400. At that time, oh, you say 350, so you might look as a cheaper lawyer, and they're ready to come to you, and that shopping around arrangement has a potential risk there. So the risk is the following: that the cost of $50 to some client may be very significant, and they're shopping around to see, I just want a certificate. That's all I want right now. But what the lawyer has to be very aware of is the fact that it is not the $50 difference that's going to be important. It is the question of what the client will think in the future, that you are negligent or not is going to be future. The person that you're advising, who is your client at that time, is the very person who will turn against you and say that, oh, I don't remember you saying this part to me, and I didn't understand it. So what I recommend for the lawyers and also for the clients that you represent is that you have a detailed discussion with a checklist. And these checklists are available, by the way, for the lawyers. They can get it from the Law Pro, and you can see certain certificates, especially in property issues, that can be very significant in terms of dealing with many issues. So in my practice, what I used to do is to go through not just the mechanical issues of the list of things they ought to know. For example, somebody's borrowing the money of $500,000 for a business venture in which the wife was asked to provide a guarantee. So when the person comes to you and says, okay, can I get a certificate of legal advice? At that time, the only thing that is relevant in their mind is the document with the signature, which you take to the bank, and the bank is happy to give the money. But the bank is relying on you at that time to make sure that you kept the client fully aware of what they signed and what the implications are. So what I do, and I prefer to do, and I suggest other lawyers do it as well, is to get the context of the relationship between the parties. What is your relationship? Will you put under any pressure to sign a document? And where it appears in your discussion with the client that there may be some pressure put by the husband or somebody, then you immediately have to make a notice and to the client that, look, you can't say on a document that you signed voluntarily when in fact you are under pressure to sign the document, and therefore if the time comes when the action is to be brought, you bring it against the lawyer because they didn't explain that it was voluntary and didn't understand the situation properly, and then all sort of allegations are made against the lawyer at that time. So important thing to remember, which is also not taught in the school system properly, is the following, that the negligence action for failure to provide advice fully is a question of subjective evaluation by the plaintiff. So that also is not something taught clearly in the school books, in your admission notes as well, to explain that who makes the decision of negligence. It's the client or a former client that came there looking for a good bargain and a piece of paper to say, I've been advised. But that person, is he likely to then come around to then say that, well, because I'm now sued by the bank, I need to sue you as a lawyer because I didn't understand what was being said to me when you were rushing to tell me, and the issues in the independent legal advice document. And now I am beginning to understand. My understanding of the client then comes from the fact that the person is being sued. Then you become more sensitive. When you're losing your house or a large amount of money, then the lawyer is the easy person to blame. So in Ontario or in Canadian jurisdictions, that is a serious issue that you have to be aware of and be prepared to deal with by sufficient amount of documentation that you do, so that in the long run, you are able to anytime come up with a checklist to make sure that context in which the person said, I will sign a document of ILA is fully explained to the person, and the full arrangement, property, how it was bought, what was done with the property, and what is the reason for doing this guarantee in the context in which they're signing it is also very relevant, even if it's in the checklist or not in the checklist. So that's my suggestion, Shalaka, in terms of the ILA in the commercial types of transactions, when the people who come to you, and the other part, I take even the precaution that if you're advising for example, the wife, then you should have the husband, if he brought the wife to the office, then let him sit outside or ask the question after you close the door that did you have any pressure put on you to sign the document? And if a simple gesture is extremely relevant from my point of view, because it is so easy to simply say that in my perception, it is simply after 5 years of time when the person is sued, that the person begins to look to the lawyer to blame that lawyer for the ILA, which they didn't understand. So that's my point. So any questions on that?
No, sir.
Good. So it was a pleasure talking to you, Shalaka. And
Same here, sir.
yeah, so I think I suggest to you that you put this on your website and other social media, and we'll do more programs, and we will try to do them on Saturdays. Other people in our group, they'll watch it on my group, and you can get to know them as well. Any person who would like to join our group is welcome to join, and they can see on the Facebook Angel Mentorship Group, and anybody is welcome to join. Thank you.